Hello everybody, this is Instructor Damian Fleming, and the course is Introduction to Criminal Justice. In our first topic, we'll be talking about crime and criminal justice. By the end of this topic, students will be able to learn the basic definition of crime and justice, be familiar with the concepts of criminal justice system, both formal and informal, the principle of procedure regularity, the principle of objectivity, and just a simple guide to the steps to the criminal justice process. For this introduction, the criminal justice plays an important role in a democratic society. In a large, diverse, and complex society, the maintenance of law and order requires authorities who are empowered to restrict the liberties of citizens, to use force to compel obedience of the law, and to sanction those who disobey society's laws. Yet at the same time, citizens must be free to exercise the liberties guaranteed by the Constitution. Thus, the law must also allow reasonable exercises of freedoms when those actions do not proceed with the actions that are held up by the Constitution. Balancing the exercise of civil liberties against the need for law and order is a difficult and complex mission. In our first topic, we're going to go with understanding the criminal justice system. The United States has experienced crime throughout its history. In the Old West, justice was administered by legendary lawmen such as Wyatt Earp. This was little in the way of formal criminal justice system. The term criminal justice was prominent around 1967, when the President's Commission of Law Enforcement and Administration of Justice began a study of the nation's crime problem. Since then, a field has emerged that uses knowledge from various disciplines in an attempt to understand what causes people to commit crimes and how to deal with the crime problem in general. Criminal justice then constitutes the study of crime and the agency concerned with its prevention and control. There are a number of different prospects of criminal justice today. The crime control perspective is oriented towards deterring criminal behavior and incapacitating serious criminal offenders. The rehabilitation model views the justice system as a treatment against focus on helping the offenders only, such as counseling programs are stressed over punishment and deterrent strategies. The due process sees the justice system as a legal process. The concern here is that every defendant receives the full share of legal rights granted under the law. In the second former chapter, we're going to be familiar with the concepts of the criminal justice system, both formal and informal. Criminal procedures is a very embodiment of all phrases that, like that of the constitutional democrat, such as checks and balances, separations of power, federalism, and constitutionalism. These are the kinds of things that might study from the theoretical perspective in a political science class. Think of the criminal procedure as a study of constitutional democracy from the applied perspective. The criminal procedure also brings balance to criminal law, because the ultimate ends of the criminal law are dual, conflicting, and contradictory. To acquit the innocent and to convict the guilty. It's difficult to set up any kind of machinery of justice that accomplish both these goals. The easier you make it to provide guilt, the more difficult it is to establish innocence. Criminal procedures therefore provides the only way to enforce the criminal law in a balanced manner. You cannot enforce the criminal law without criminal procedures. There are a number of gritty little things that need balancing in our society. And throughout the devils and details, here are a couple of general categories. Society and the individual. Both must be controlled. Human nature being what it is, people will misbehave. Power being what it is, governments will abuse it. Criminal procedure is based on assumptions that human nature as well as societal evolution is imperfect. Formal and informal. Formally, every decision point in the criminal justice system is governed by rules. But informally, every decision in the system is characterized by discretion. There are many reasons for discretion, but the general idea is that full enforcement is not economical. Ends and means. In criminal procedure, we also don't believe in the search for perfect truth. Even proof beyond reasonable doubt is not absolute proof. Constitutional democracy do not believe in achieving ends by any means necessary. And we are not a society that believes in justice means. The truth in any price is too costly. So we settle for the least goal of correctness. Not perfect, but little or no error. The innocent go free, the guilty get convicted. Most of the time, the results are what matters, who crosses the finish line. Some people have called this sporting theory of justice because of a similarity to sports. Yet even correctness to stringent and needs balance. So the Supreme Court has allowed us to use reasonable doubt. However, we still need a way to balance and emphasize on product with the emphasis on process. The entire history of the criminal justice procedure has been a pendulum swing between the emphasis on product and the emphasis on process. The principle of procedure regularity. Sometimes fairness requires reaching beyond correctness. At this point, you're probably asking yourself, why fairness? And the answer is the most conceptions of fairness assumes to be a number of other concepts. It's most general in all these concepts. Fair. A straight, clear, free, constant, just conformity with what is right or properly and ethical, dedicated to the conscience, reason, or sense imperishable without bias. Without favoritism, objective detachment in the observation. The notice of the concept objective means detachment in the observation and judgment going on the facts, not a hunch or suspicion. It is part of our second principle of criminal procedure. The principle of objectivity. Don't let the look of these things in the checklist fool you. The principle of objectivity is the continuum, not a dualism. The general idea is that most of the invasions in the private affairs, the more the need for objectivity. In the first place, the law of criminal procedures is what empowers the public to invade the private. The criminal law does this, and it only prescribes the private from invading the private, or the private from invading the public. The distinguishing feature of the criminal procedure is that it justifies the government's intrusion into private life. The role of criminal procedures is to maintain the social interest and quality of life. If you were to crack down on crime by any means necessary, you might end up with a crime-free society. But at what cost? And would you want to live in such a dragonatic atmosphere? If you were to exclusively restrain the government from intruding into personal life, you probably have a weak government and eventually an anarchy. The trick is to provide the government with just enough power to intrude so it can do its job of keeping us free from crime, but not so much power that it threatens our quality of life. Crime detection steps include both proactive and reactive strategies by the police. Everyone's a suspect. When investigation focuses on a specific suspect, the process enters what is called a preliminary stage. Once police believe that the specific suspect has committed a specific crime, the process enters the arrest stage. Juveniles are diverted from this system at this point, following arrest in the search stage, but searches can occur before arrest in some instances. Then arrests are followed by booking. Finally, a follow-up investigation is done with complete police action. Criminal prosecution steps. The police transfers materials from prosecutors who decide in charging stages what crimes have been committed, if any. If they decide to charge, the process enters the compliance stage, which is followed by adjudication, which means formal proceedings in court. There are 5 important formal proceedings. The first, appearance, which only takes a few minutes and sets the balls if there's probable cause for arrest. Preliminary hearing, which tests the government's case by determining if there is a probable cause to try the case. The arraignment, which signals that the government has passed all previous evidentiary tests and is now required a plea from the accuser or the accused. Pre-trial motions made by either prosecutor or defense counsel to challenge certain types of evidence to the court's authority to hear the case. And last, the trial, the high point of the criminal justice process with or without a jury. Official decreases of the judgment by the judge, who has acted as an umpire up until now. The decree of the judge allows overrides by any jury recommendations. During the appeal steps, attacks on the conviction by the convicted offender by either claiming innocence or error. Another type of review is a collateral attack, or habeas corpus, which challenges the lawfulness of the detention on constitutional grounds. During the punishment steps, everything here is the duty of the correctional officers, the correctional officials itself. The must of the objective basis is invading privacy, liberty, or property. Without getting into the attempts to define privacy, liberty, or property, suffice in it to say that it's follow areas by determining the Constitution